Hello, everyone, and thank you for joining the sixth session in the AIA in California's Fire Response Series. Fire Response Session 6, Legal Protections, Minimizing Exposure in Disaster Relief Work. As you get settled, please feel free to say hello and where you're joining from in the chat today. To qualify for continuing education credit, AIA California provides the learning objectives for every webinar and includes them in the presentation that can be made available online. A few quick housekeeping reminders. Today's session is being recorded and qualifies for one AIA HSW learning unit. For those who stay on and watch live, AIA California staff will report these units for you and will send follow-up information on how you can request a certificate of completion. Please use the Q&A function to ask any questions for today's presenters. You can also like a question to move it to the top of the queue. Please be constructive in your comments and questions to help foster a positive learning experience for everyone. We are so grateful to have so many speakers participating in today's session. But first, I'd like to introduce our moderator for today. Alex Atkinson, AIA, is a licensed architect and urban designer and serves as Director of Programs on the board of the AIA in Pasadena Foothills chapter. Based in Pasadena, Alex is co-founder and president of the Foothill Catalog Foundation, a nonprofit organization geared towards developing attainable rebuilding solutions for displaced residents following the Los Angeles wildfires. Thank you so much, Alex, for being here, and I will hand it over to you.
Great. Yeah, thank you very much, Sarah. And good afternoon, everyone. And welcome to Legal Protections Understanding Risk in Pro Bono and Self-Certified Work. We're glad you're here for what promises to be a timely and essential conversation for architects working in disaster recovery. Today's webinar will focus on how legal and ethical responsibilities are affected in disaster recovery efforts, with a particular focus on the implications of certification, in particular, as well as pro bono services. We'll examine how the standard of care applies in these urgent scenarios, especially when timelines are compressed and oversight is needed. We'll also talk through time limits on post-disaster protections, professional liability exposure, and strategies to mitigate risk when stepping into these critical but complex roles. Expect a clear overview of what architectural services are typically offered after a disaster and how to navigate the tension between urgency and thoroughness. The session is about equipping you to serve your communities responsibly without compromising your license or legal standing. So let's get started. We have a great series of panelists, as you can see from the screen. We're going to begin with a representative from California Architects Board, Michael Scanga. And Michael Scanga has been the lead enforcement analyst for the California Architects Board since 2019. At the direction of Executive Officer Laura Zuniga and Program Manager Alicia Kroger, Mike leads a team of 6 analysts and technicians responsible for enforcing the Architects Practice Act for the state of California. The enforcement unit and their subject matter experts investigate approximately 500 complaints each year against architects and unlicensed engineers or designers. They make recommendations to the board for administrative and disciplinary actions ranging from warning letters up to license suspensions and revocations. Mike holds a PhD and a JD. He is not an architect. And with that, I'll turn it over to Mike.
Thank you very much. Let me share my screen here. Thank you very much for inviting me. My name is Mike Scanga, again, lead enforcement analyst at the California Architects Board. I'm going to just jump right into it and first give you some resources to look at if you're not familiar with the Architect Board's website, cab.ca.gov. There's a few different features on there that you should be aware of, and I understand that this slide presentation will be available to everyone later, so you don't have to write everything down now. But there is a form that you can use to send emails depending on your inquiry. If you're a candidate for licensure or a licensee with questions about renewal or CE or anything like that, if you have any questions about enforcement, if you use that form under the Contact Us page and choose enforcement, it'll come right to me. And that's the fastest way to get a hold of anyone in the enforcement unit We also have what's called the Connect platform. It's not an imaginative name, but it is useful for, it's used for license application, renewal. There's also a complaint form through the Connect portal, and you'll find that also on our website. We have a tab for resources that includes the full Architects Practice Act, which is what I'm going to be talking about today. That's the limit of our jurisdiction. So everything that I'm referencing, all the code sections I'm referencing today are in the Architects Practice Act, which you can access through there. We also have a number of publications that address issues that we're talking about today. We have newsletters from the board members and the board president going back years, and we have a frequently asked questions section that addresses a lot of other issues. If you're interested in a more in-depth dive, you can look at the About Us tab, which has all of the prior board meeting packets and training. So for example, at the last board meeting just a couple weeks ago, I gave a training on the enforcement process. If you're interested in more in-depth analysis of the enforcement process, you can watch that video or read the transcript on that About Us page. I've been asked to talk about licensing issues and professional boundaries during emergencies. So again, the Architects Practice Act, it moves slowly, so there have not been a lot of things adapted directly to the current state of emergency, and generally there have been no changes to things such as qualifications for licensure, the CE requirements, business entity reporting requirements, stamp requirements, and business formation. So you still can't use, for example, an LLC to provide architectural services in California, but that's a minor issue. There are a few existing provisions in the Architects Practice Act that do address the state of emergency. And first one I'll mention is 5536.3, that's Business and Professions Code section that requires the release of plans for insurance purposes. And 5536.5, which is much more active, increases the penalties for unlicensed practice and advertising directed towards fire victims or emergency victims. We've used that for years to try to prevent unlicensed practice. It raises the fines up to $10,000 per incident and actually makes some of the violations a felony. So the local district attorney's offices are much more likely to take up those unlicensed practice and advertising cases than they are other times of the season. There are some pending regulations that are addressing the current state of affairs, including amendments to California Code of Regulations, Section 109, which extends the time of license eligibility. So if you're a candidate for licensure, you currently under Section 109 have a 5-year deadline from your first application to your last exam. So now this amendment would increase that time for candidates that were displaced or suffered hardship as a result of the state of emergency. Pending Senate Bill 641 is also expected to pass and will make it easier to obtain a duplicate copy of your license or to change your address. There is one section that I'm reluctant to talk about because I want you to understand that even though when professional services are provided without compensation, which is one of the things we're talking about today, there is actually an exemption to the written contract requirement under BPC 5536.22. That doesn't mean it's a good idea, and the rest of my talk is going to be about why you should document everything, and especially the scope of services. So you're strongly advised to have a written contract, even though this exemption does apply to voluntary service. I just want to say, for example, your written contract, when we receive a complaint, that's the first thing we're going to look at, because that is the easiest way to decide whether there's potential Practice Act violation or not. Okay, so I want to talk about the Architect Board's role after disasters, investigations that we do, enforcement in general, and guidance that we provide. I'm going to take you through the enforcement process. I'm going to list and talk about a few potential licensee violations to be aware of in the Architects Practice Act, and then point you towards some publications we have that should help you understand how to avoid those. This is an overview of the enforcement process. So first step is intake. We receive complaints from all sorts of different sources, whether they're clients, building officials, other architects. We also receive anonymous and confidential complaints through a number of different portals. For example, I mentioned Connect before, but we also just receive emails, we receive faxes, we receive phone calls, everything. So the first thing we do with those is do a preliminary review of the case to make sure that the allegations have something to do with the Architects Practice Act. So we have to define whether it's within our jurisdiction, whether it's within the statute of limitations that applies, and it's not just an architect kicked my dog sort of thing, which we do get quite a few of those. Not the dog thing, but similar. Then the case, once we establish that there is some evidence or some allegation of a Architects Practice Act violation, it gets assigned to an analyst who generally specializes in that sort of case. We have 6 analysts for the entire state of California. We get about 500 complaints a year, so our caseloads are very high. But we take a look immediately to see if we can verify the potential violation. Then we collect evidence, usually documents, especially the written contract is important. Any plans, especially preliminary plans or plan check comments that are the source of the discontent. And then we get full statements from the complainant and the subject of the investigation. If the investigation involves matters of negligence or incompetence or recklessness, the case gets referred to a subject matter expert who is a licensed architect in California and can guide us on industry standards. If the allegations include any sort of criminal activity, the case gets referred to the Division of Investigation, State Division of Investigation. They have sworn officers that can do everything from sting operations to referring cases to the district attorneys. We do a full analysis of penalty considerations, which might make the difference, even if there is some negligence between a letter of advisement and a citation or an enforcement action against somebody's license. So we have a variety of actions that we can take. Complaint closure can just be closing the case. Letter of advisement is a little bit more formal warning that you are violating some provision of the Architects Practice Act, that you need to fix that. And if we get another complaint about the same thing, that we're more likely to take action. Action can include citations with fines up to $5,000 per incident, $10,000 under a state of emergency. Or we can refer them to the Attorney General to take disciplinary action or deny a license to a candidate who has applied. We certainly have a priority for cases with demonstrated consumer harm or threat to safety, so those cases go to the front of the line. I just wanted to go again over the penalty considerations. The things that we're looking at are the extent of consumer harm, whether a person has a prior history of misconduct, and, you know, a kind of a catch-all, whether the subject is, expresses recognition of their wrongdoing, if they're, comply with our investigation, that sort of thing. So all of that goes into the decision of how far to take any disciplinary action. These are the sorts of disciplinary actions that we're talking about. Disciplinary misconduct, again, negligence, incompetence, and recklessness, those sorts of cases would generally be reviewed by a licensed architect. Willful misconduct is described in California Code of Regulations, Section 150. It has to do with essentially breaching your contract with a client and not making it right, is the best way for me to describe that. Fraud in the practice, we'll talk about that in just a minute, but generally any sort of misrepresentation, direct misrepresentation to either the client or the building department, that sort of thing. Aiding unlicensed practice, there's several different varieties of that. Look at CCR 151 for a little bit more detail. Essentially failing to exercise responsible control over your drafters or unlicensed designers that you work with. Conflict of interest can be, it's generally a lack of disclosure. Conflict of interest and full disclosure kind of go together. The big red flag that where we see these come up is when an architect is both the designer and the builder in a project, and they're essentially overseeing their own work. And then again, written contract violations, you should be familiar, any licensed architect should be familiar with BPC 5536.22. There's a list of exactly 8 terms that have to be in every architect's written contract with their client. Regarding self-certification issues and the self-certification program, I would say one thing that you really have to watch out for is potential for fraud in the practice, which could be alleged if you're misrepresenting your qualifications to be in the program, or you're misrepresenting compliance to the building department. Additional qualifications may be required. So I think, for example, the LA City program requires that you've been an architect for 3 years or something. So the local agencies can impose additional qualifications on you to participate in those programs. They can't impose fewer, so they can't make an unlicensed person eligible to design a new commercial building, for example. Scope of responsibility issues, again, this is where the importance of the written contract comes in. It's the first thing that we're going to look at to see if the complaint against you is within your scope of responsibility. As the other folks will tell you today, that it's very important to maintain all of your correspondence related to changes in that scope of responsibility. So that's, I know it happens quickly sometimes, but that's where it's going to come down to whether it's a violation or not.
And Michael, I'll ask to kind of, we'll leave it at that as a good transition into the next few presenters. I want to make sure we have some times for questions at the end. So we can turn it over to Julia now. Okay. And I'll let you guys change slides. But Julia Donahoe, AIA, is an architect, attorney, general contractor, and brings multidisciplinary knowledge to the field of disaster recovery. After the Tubbs Fire of 2017 burned into the heart of her community, she headed the AIA Redwood Empire Disaster Recovery Committee and became an expert in the process of recovery and rebuilding after a disaster. Beginning in 2018, Donahoe helped create a startup company serving as Vice President General Counsel of Homebound Construction, Inc., that is rebuilding homes faster after disaster using technology, and participated in the 2022-2023 advisory group for HUD's Designing for Natural Disaster, a resilience guide for builders and developers, chairing the fire section. She has continued to serve on the California Disaster Area Network, has created a toolkit for California components to respond to disaster, and is now serving on the AIA National Disaster Assistance Committee. So Julia, take it away.
Thank you so much. And that was an excellent overview of the California Architects Board process. Helped me. I'm dealing with a complaint with a contractor, so it's always good to understand how it works. Today, I've been asked to talk about the AIA Code of Ethics, AIA contract provisions, and give examples of AIA initiatives post-disaster, and talk about the resources available to architects. Mostly in regard to what can we do after disaster. I always like to remind people that one of our gold medalists from California, Julia Morgan, started her career in 1902. 2 years later, she was licensed in 1904, so she was an intern at a campus architect for 2 years. And then the earthquake happened in 1906 and destroyed her office. She rebuilt the Fairmont Hotel in 1 year with reinforced concrete. She was like the only person in town who understood it. She changed building codes in 4 months, which is unheard of. The San Francisco Municipal Building Code included reinforced concrete for all kinds of structural elements within 4 months of that disaster because of her Mills College Tower. And she 10x'd her workload in her office. She jump-started her career with her involvement in the disaster. So I just like to remind people that architects are team leaders. They can dive into this, and it can be very, very good for their career. I gotta set my timer because so the AIA Code of Ethics. So the AIA Code of Ethics has some general provisions, and then it has some specific provisions. And it's really good to think about this when you're facing disaster, because people who have lost their homes, lost their buildings, lost their livelihood are pretty distraught in this moment. And this is the time when we can be the most professional and come to the table to help people in ways that really require a high degree of professionalism. A lot of the contractors, I gotta say, are also highly professional, but there are a lot in the contracting world who do deviate. So this is a time when you can really protect people's assets and their get them back to their livelihood quickly. You can help rebuild your whole community. So all of these things are really, really important. And over the last few years, I put the link here for the Code of Ethics, so you can look it up later. But I also wanted to just bring 2 of these provisions up. This one, the general obligations, members should maintain and advance their knowledge of the art and science of architecture and so forth. That's really important after disaster. You have to actually 10x your knowledge of resilient design practices so that you build back better. And then also there's all these AIA initiatives now that deal with climate change, resilience, and disaster kind of all together. And it's all coming together at the national and the state level to become a major focus. Where green was before, sustainability was before, this is the new trend with the AIA, is to really focus on this area. So, but this is the place where we need to bring our most professional demeanor. I'd just like to remind everybody that there are many phases of disaster: becoming ready, responding, which is the days after the disaster, recovery, which is where we are now with Los Angeles. Rebuilding takes years. Recovery is the months after the disaster. We're starting to transition to rebuilding for some people. Some people it's going to take longer before they even get started. And then after you're done, you want to go back and review. But architects can be involved in all of those phases, and there's different roles that they can play in those phases. So if you've seen my other presentations, you've already seen that slide, and it's available in the toolkit. So I want to talk about a little bit about the contracts that we have. The architect's contracts, the B101, the architect owner contract, is your main tool for your relationship with your owner. And if you do letter forms of agreement, that's fine too. But all the standard clauses are in there that you need to have, and that's all going to conform with what he was just talking about, the Business and Professions Code 5536.22. But I like to bring up the fact that a lot of time when you're overburdened, you'll have a tendency to let construction administration go to the wayside and say, I've got to design more projects and get construction documents out, and contractors can take care of that part. But like I said, I'm a lawyer, architect, and contractor, and the contractors are the ones who can either be most professional or most fraudulent in this scenario, because there's a lot of money on the table. The insurance company is dumping billions of dollars, the insurance industry is dumping billions of dollars into Los Angeles, and there's this pile of money. And you know, it's less likely for architects to be fraudulent, because architects kind of have to fight with the insurance companies to get paid appropriately. But the contractors, money's coming in, they tell their subs and their material suppliers, the homeowner hasn't paid me, the property owner hasn't paid me, I'll pay you when I get paid by the insurance company. That's the line they use, and then they take the money and they leave town. So, you know, I still am working on some cases where they took millions of dollars out of town and moved to Texas, and they left houses unfinished. So CA is where you can really protect someone's assets. And so I just like to put that plug in. But it's all the same scope of work, except in a disaster, you want to consider, what is your role? What is your role? This is from the AIA website for the contracts. And you can, there's like 375 different documents that you can use there. But this one, team manager, was really set up for BIM. So if you go into the team manager button, then you'll find a bunch of BIM type documents. But team leader is really a role that you can take on more than just being an architect in this phase. Property owners are having to do about 20 different contracts in this phase. They're having to do debris removal, environmental testing, soils testing, all the different engineers and energy consultants, because the contracting or the permitting is more difficult. And then construction contracts, interior design, you know, there can be up to 20 different contracts, and the architect can be the team leader for the whole thing. With FEMA going away, especially, this becomes important, because that debris removal and the emergency response kind of puts us on the back burner, and then people just go straight to the contractor a lot of times. But with FEMA disappearing from that piece, what they were providing is project management. They provided it at a huge cost. It was like $80,000 of project management for FEMA to clean up a lot, whereas the local guy only got paid 20, and he's still going to get paid 20 no matter who's managing it. But this is a role that architects can take from the beginning. Become a team leader and help a property owner with everything from debris removal to moving. And so the contracts right now, I feel like, don't really encompass what that might be. So the AIA contracts, you can piece it together, but I think that's an area where they could expand. So I'm hoping that will happen. I just want to remind people there are different kinds of services you can provide during a disaster based on the time frame, some of which are pro bono and some of which get paid for. And it's important to understand the differences. So you can do safety assessments, that's early on. You can help in the local assistance center. You can do workshops, group one-on-one. You can help with the recovery permit planning, and all of those things can be through the AIA component and through the state AIA, organizing together with your colleagues. The most important thing about that kind of consulting, one-on-one workshops, whether it's phone-in workshops or Zoom workshops, is having waivers signed so that you're not incurring liability and you're not creating a contractual relationship. You need to be really clear with people, like I said at the beginning, being professional, being clear, making sure that people don't think that you're already providing them services and that you're doing this as a volunteer. So you just have to be really clear about those things. And so I have an example of a waiver here on the next slide. But then the design and engineering is where you can really make money. Doctors make money from insurance, attorneys make money from insurance claims, Now architects can make money from insurance claims also. So that's important to start understanding that that stuff doesn't have to be pro bono, and it shouldn't be pro bono, because that liability does kick in and you want to be paid for your work, and you have a business to run. So it's a lot of work once you're getting past the initial volunteer stuff. So it's really important to understand you don't need to be giving away design services unless it's for the people who aren't insured or that were in the low income situations and so forth. And then I come back to that, you have a role that you can fulfill here, protecting a vulnerable population. There's a lot of fraud on the construction side that I'm still dealing with from a 2018 fires. So keep that in mind, that there's a role for architects to play there. So here's just an example of a sign-in sheet waiver that we used in our chapter. You can write a one-page waiver. There's all sorts of waivers available. You can have a lawyer help you draft a waiver for meeting with someone on one-on-one, but that's one of the ways to defer the liability. Understanding the insurance is also really, really important. This is a spreadsheet that I make for people. I only have a few maybe a minute or two left. So you can see here on the right under project estimates, soft costs can be definitely a part of the equation, and you have to figure out how their total money situation works with what your fees are, and you have to make sure the insurance is going to pay for it. So they do, by state law, have to pay for the fees, but the fees have to be fair and reasonable for the size, like, kind, and quality of the project. I just want you to know that with AIA, we have this toolkit. Most of you have already seen my presentation on that, but that's online. So that's online, and AIA has a bunch of other resources for you. Also, one of the biggest resources for everyone at this point is getting together with your colleagues, however you get involved with the local AIA. That's a huge resource during this time. Organizing along different knowledge groups and having ongoing relationships for several years with a small group of people that you have interest in the same topics. And then just being aware that architects really are leaders in innovation and resilience, and building back better is really all that we're about. So that's how you work with your colleagues. You get your education through your chapter, and then here are some of the resources that are available through the AIA and through national in California. And you can look at that slide there. Thank you.
Great, thank you, Julia. We're going to turn over now to Brian K. Stewart. As a trial attorney at his firm's Pasadena office and managing partner, Mr. Stewart predominantly handles professional liability and catastrophic injury matters. He represents professionals in all aspects of their practice, with an emphasis in representation of design professionals, including contract review and negotiation, mediation, arbitration, and trial. In addition, Mr. Stewart is active on various committees for both the American Council of Engineering Companies of California and the American Institute of Architects California Council. He was a member of the ACEC California subcommittee that successfully assisted in getting fair indemnity legislation for the design professional community via SB 496, passed in California in 2017. In 2009, he was awarded the Honorable AIA-CC designation. In 2014, he received the Presidential Citation from AIA-CC. In 2016, he received the Honorable AIA-LA designation. He has received an AV preeminent rating from Martindale-Huel, the highest rating that organization bestows for both ethics and ability. In addition, Super Lawyer magazine has designated Mr. Stewart as a super lawyer in the area of professional liability since 2013. Brian, take it away.
Thanks for that kind introduction, Alex, and welcome everyone to our webinar. This is my opportunity to join in as the second lawyer on this panel, following Julia with a little different perspective. So we're talking about the legal protections and understanding the risk. Predominantly on the self-certified work, I'll touch briefly on the pro bono area at the end of my conversation with you today, but we're going to concentrate on the self-certified work. So Pro bono and self-certified work. Is it a dream come true, or is it a nightmare realized? You are in control of how this will end to a large degree. So here's the overview of what we're going to talk about today, really the risk that comes with it. I think some people think if I'm doing this work for free, I shouldn't have any liability exposure. Well, unfortunately, that is not the case. You essentially have the same liability exposure for doing work for free as you do for doing work that you're well compensated for. So, and the last thing we're going to talk about is some Good Samaritan laws that have very narrow application. All right, how did I get here? You may be familiar with these two individuals. One just got sentenced to jail, and I'm not sure about the other one. But I started out as a baby lawyer before I started to look like at least one of these guys, probably not the other one. So standard of care, that was going to be the focus of my conversation today. And a lot of people think that it's by regulation or it's by law. Predominantly in California, it is the result of case law. And what resulted due to the case law are some very, very good and beneficial jury instructions. So ultimately, if you are sued for professional negligence, whether you're paid or not, this is what the party suing you needs to prove: that you failed to use the skill and care that a reasonably careful architect would have used in similar circumstances. That is the standard of care. And juries are supposed to only listen to the experts, qualified experts. Most often, if you're an architect, they would also be a registered architect in the state of California. But you, as a defendant, should you unfortunately get sued, your testimony on what you did and why you did it could be considered by the jury to inform them and define the standard of care. Now, I have tried close to 50 jury trials, to verdict. Many of them included or were involving defense of either architects or engineers. The next instruction is probably my favorite jury instruction, in a rare instance where California law is actually beneficial to the professional, and that is success is not required. That is very critical, because you're a professional. You're not guaranteeing your success unless you make the mistake of including it in your contract. But basically, this jury instruction stands for, and this is given if asked, and it will be given in every professional liability case against an architect. And just because you made a mistake, unless it fell below the standard of care, does not necessarily mean that you fell below the standard of care and that you were therefore negligent. Even the AIA recognizes this. This is in the standard language in the AIA documents, a very benign and gentle form of defining the standard of care. But who decides the standard of care? Well, it's the jury. And if you go to court, you're putting your fate into the hands of 12 people who weren't smart enough to get out of jury duty, as Norm Crosby described it. So I'm going to define the problem first, and then I'm going to propose some solutions to self-certification. From my perspective, it takes the pesky public agency out of the approval process. And I looked up pesky, is a word I came up with, annoying and troublesome. I'm not sure agencies are annoying or troublesome. Actually, they provide some checks and balances. Sometimes they catch architects when they're about ready to make a mistake and save them from a bigger mistake, that it gets actually built wrong. Sometimes they can be a little bit of a nuisance. But I also want to make it very clear that when you're doing self-certification, there's no limitation of liability or immunity that comes with it. And it also doesn't alter the role of field inspections. Some of you have had the unfortunate experience, I'm sure, where something gets approved in planning and also gets improved through plan check, and then some pesky, I'll use that word again, field inspector calls you on it. And even though it was approved in the home office or the public agency, it doesn't mean that the field inspector is going to pass it. So there is that problem out there, and I think it's a very real problem. So they provide checks and balances, or if without them, there's a possibility that you may actually have to write checks. And I don't think you'll be as fortunate as Babe Ruth. That's a copy of one of his checks, who had the distinction of having most of his checks never cashed because they were in small amounts and everybody wanted Babe Ruth's signature. So unlike Babe Ruth, most architects will not be that fortunate. If you write a check, I think people will cash it. So the solution, and I also have in small print on purpose, if there is one. Contractual limitation liability is legal in California. It's enforceable under the code. And I was the lawyer when I was at that baby lawyer picture. I argued this case way back in 1991 when I've been practicing for 5 years to the California Appellate Court. Still good law. It's called Mark Berger versus Superior Court. In that case, the fees were limited to $62,640 or $50,000, whichever was greater. In that case, the fees were $62,640. Therefore, that is what we settled the case for. So you can't get a complete waiver either for future acts. It's void against public policy. My recommendation is a limitation liability clause, if you're going to do the self-certification or any contract, frankly, is the best way to go. But what about indemnity and hold harmless? They are helpful, but they cannot protect you from your sole negligence or willful misconduct. It's written right in the statutes in California. What that means is if there's a failure because you self-certify and it's a problem related to design, there's a good argument that it would arise out of your sole negligence because you were the designer, and therefore an indemnity clause may not protect you. The other solution is to be very, very careful. I think having contractual indemnity, if you're going to give the owner the benefit of a speedier project, right? The bargain for exchange is you're not going to have the benefit of plan check, neither is the owner, but that's going to make the project go faster to their benefit. They have to sacrifice some things. So I think it's a bargain for exchange, and that's why you should endeavor to get those contractual protections put in place. As Michael said earlier, and he works for the state, even if you're doing a project pro bono, it's really a good idea to lay out the terms pursuant to 5536 of the Business and Professions Code, even though technically speaking, pro bono contracts are exempted. The part about being very, very, very careful as I conclude this slide is there's a probability you're still going to make mistakes. And so that safety net is your contract, just in case even the most careful person will make mistakes. So, Good Samaritan rule, that is when there's a declared national, state, or local emergency, and you have to have that to qualify under this code section. You also can't get paid. So if you ask for compensation or have an expectation of compensation, this Good Samaritan law will not apply. It also doesn't cover gross negligence or willful misconduct. I've had at least one and maybe two cases over my almost 40 years where someone alleged gross negligence to try to get around the statute, and we had to battle it. And it only covers inspections within about 30 days of the declared emergency, so it doesn't last for a particularly long time. So I'll save this one for the end, and I'm faster than the other folks, so that'll save time for questions at the end. I believe in being passionately curious, and I think most architects are as well. Thank you for your time.
Great, thank you, Brian. And we'll turn it over last to Mark H. Saville. Is a licensed architect and general contractor with over 4 decades of experience. Mr. Saville is a graduate of the Southern California Institute of Architecture and the founding principal of Mark H. Saville Architects, Inc. With over 4 decades of experience and licenses in multiple states, his expertise spans a wide range of architectural and forensic services. His contributions to the field, including his work on building codes and forensic investigations, highlight his dedication and impact. Mr. Saville's firm offers architectural and forensic services to a diverse clientele of businesses, institutions, government entities, community associations, insurance companies, and homeowners. His forensic investigative services have included the subjects of architect standard of care, contractor standard of care, structure collapse, building performance, fire loss, and post-damage reconstruction. He has chaired the AIA-LA, LADBS Code Committee, participated with LAFD towards enacting changes to the code, and led an investigation of a tragic collapse that resulted in a significant change to the California Building Code. Mark, take it away.
Thank you, Alex. I almost believe that. So what I hope to cover today is 4 basic categories. 1, realistic expectations of architects' performance in disasters. Talk about documentation, communication, and coordination challenges, insurance implications, and how to assess when you're competent to take on the task under emergency conditions. Just move along. So let's talk about understanding disasters. 1, it's a sudden, unexpected event, and it could lead to significant damage and destruction to loss of life. There's natural disasters, which we understand to be wildfires, earthquakes, landslides, severe weather, and flooding, which we've all experienced in California. And then there's the man-made disasters. There's those that include chemical spills, terrorism, nuclear accidents, and war. But we know that each of these can have a severe consequence that affect people, building, economics, and environment. So we look to the architects among those that should be both active and reactive. We say proactive and reactive. And it's if for those that wanted to respond to include pro bono services, what we look at is a basic understanding. And as has been discussed already this afternoon, it's understood that the architect's pro bono services come with no financial or monetary compensation. And I'll mention that a couple more times today. So let's talk about proactive design and planning. First of all, it's the basic concept is that we want to resist and endure extreme events. We talk about structural integrity. We talk about wind events, seismic events, flooding, fires. We want to make sure that we're using the appropriate construction materials, reinforcing frameworks, elevating structures in flood-prone areas, and fire-resistant materials and assemblies. There are websites that help us provide that information, support our analysis and information. We want to talk about flexibility in adaptive spaces, primarily for public works, public buildings. We're looking at schools, community centers that can be designed where they're easily converted into shelters and medical facilities. And then in regards to our designs, we want to include redundancy and robustness. And that's pretty much in the power, water, and HVAC services. We talk about reactive planning and design. It's important to remember that architecture goes beyond just the aesthetics and the design. We say that architecture plays a crucial role in disaster recovery planning by shaping resilient, safe, and adaptive environments that minimize damage and facilitate faster recovery. We know that planning encompasses strategic thinking about how buildings and infrastructure can withstand future natural and human-made catastrophes. So when we talk about the pro bono services and self-certification, we now have to think about documentation, communication, and coordination challenges. So let's talk about documentation. Our initial steps is the assessment of the site. We want to identify remaining improvements, the availability of utilities, contamination levels, site boundaries and topography, basic community resources. We have to think about the client and their intent. Do they plan to rebuild like for like? Do they want to increase or reduce square footage? And clearly, we must have an understanding of the financial impact. We talk about regulations and requirements. Do we know the local codes, ordinances, deed restrictions if they apply? And then the design and construction process. We have to remember that many of these architects will be working with disaster survivors that have never intended, never dreamed about working with an architect to reconstruct their home or design their new home. So we must maintain records, and we want to support that through meetings, information regarding changes, the progress with regulations, and certainly the approvals. When we talk about communication, again, we're referencing those first-time clients specifically and understanding the client